Welcome to Washington Legal Foundation's web seminar. My name is Glenn Lampe. I'm Chief Counsel and Vice President of Legal Studies here at the Washington Legal Foundation. For those of you not familiar with the foundation, we are in our 44th year of free enterprise advocacy, education, and litigation. We are involved in a pretty broad range of legal and regulatory issues that affect the free enterprise system, and we try to advance principles of the rule of law, due process, fair notice, things that we think are needed for the business community to thrive in the United States. If you're interested in more of what we do, I encourage you to go to WLF.org and check out our website. Some years ago at an American Tort Reform Association, I heard ATRA's General Counsel, Victor Schwartz, who's a partner of Shakardi and Bacon, talk about how some state court rules severely discriminate against defendants. One rule he mentioned really stuck in my mind: evidence that the plaintiff in an auto crash or a vehicle-related product liability case was that was not wearing their seatbelt is inadmissible. So I was pleased last year when one of our speakers offered to write a working paper for WLF on that topic, using the case study of reform in Louisiana to explain the evidentiary gag rules reasoning and the prevailing landscape. With January marking the beginning of some state legislative sessions, we thought that now would be a good time to return to the subject with this webinar. Before we get started, though, a couple of housekeeping items. The session is being recorded. You can download the working paper I mentioned by clicking on the Handouts tab that's on the right side of the screen. If you have any questions, click on the Q&A tab and hit send. We'll present those questions to our speakers during question time. And finally, I posted the link to the slides that our speakers will be presenting in a sticky note on the right-hand side as well. Introduce our speakers. Leading off is Lee Mickus, who's a partner in the Denver, Colorado office of Evans, Fears, and Schuttert. He defends manufacturers and other business interests nationally in product liability and tort lawsuits. Lee works with a wide range of products and industries, including automobiles, pharmaceuticals, medical devices, and recreational equipment. Following Lee will be Thomas Vanderford, who is the Associate General Counsel and Executive Director of Litigation for Hyundai Motor America. He advises Hyundai engineers throughout the world on product safety, product liability prevention, and regulatory compliance. Tom is very active in professional and civil justice reform organizations, including the American Bar Association and PLAC, and is a member of ATRA's board of directors. Finishing up will be Doug Lampe, who is in-house counsel at Ford Motor Company. He has global responsibility for all matters in courts of appeals and is responsible for aspects of Ford's product liability litigation, safety, and regulatory counseling, and national civil justice reform efforts as well. He's very active also in civil justice reform groups, including stints as president of the Civil Justice Reform Group and chairman of the American Tort Reform Association. Lee, if you could get us started.
Thanks very much, Glenn. It's my pleasure to speak to this audience about a topic that I've spent a great deal of time litigating and thinking about. And I think what you're going to see if we do our job here is that these statutes that are really quite pervasive just don't make a lot of sense anymore. They seem to be stuck in a way. We seem to be stuck in a wayback machine with these statutes, and these present a real opportunity for reform on either the court level or the legislative level. So to get things going, what I'm going to do is give you a little bit of an overview of what I'm going to talk about and what the other speakers are going to address, so you kind of have an idea of what we're going to cover and what's going to be discussed here today. I'm going to start with giving an overview of some of the core facts that address this issue and things that are pretty indisputable, I would say, at this point. Talk a little bit about what these gag rules are and where they are, and a little bit about how they came into being, because that's a really important part of the discussion, why they exist and why they don't make sense in today's climate. Then Tom is going to take over, and he's going to talk about how some of the justifications that may have existed back during the enactment period no longer really are the case, and talk a little bit about responses to some of the current objections that are frequently raised to reforming these statutes. Then Doug's going to pick it up and address some of the additional responses, and Doug has the pleasure of being able to show you some really compelling videos that I think are really going to make your day. I think they're just fascinating to watch, and then finish up with some of the potential reform models that can be used. And then finally, we'd welcome any questions. I think if they are just typed into the Q&A to the right of the screen, they'll get to us, and we'll have a chance to discuss those. So with that overview, let's jump into the discussion. And I'd like to talk about the first basic fact, which will probably seem obvious to a lot of people, and that is that seatbelt use has become accepted here in the United States. That wasn't always the case. Way back in the 70s and 80s, some of you who have my longer history might remember that there was an issue that people really didn't like them. There were issues with people cutting the belts or sitting on them in order to avoid some of the buzzers and chimes and other use suggestions. But that's now really in the past. Now we've got people that are driving that were part of the car seat generation who just feel naked without a seatbelt around them when they get into the vehicle. The most recent stats that I've been able to see from 2019, published by the National Highway Traffic Safety Administration, and that's the chart that you see in the slides in front of you, shows that there has been an incremental increase starting in the 80s, but especially accelerating through that, and most recently, we're now above 91% in active, consistent use among motorists. What's concerning is that last 9%, which is a persistent resistor that for whatever reason hasn't yet accepted the benefits that seatbelt belts provide. And if there's been any question about whether attitudes have changed, the Texas Supreme Court in a 2015 case, after reviewing a lot of the history, really put it pretty succinctly that attitudes about seatbelts have evolved drastically, as you see, and that's really pretty much the case. The next basic fact that I'll throw out there is seatbelt efficacy is really not in dispute anymore. For a long time, there were discussions about, geez, is it better to be belted or not belted? What about when you drive into a lake? What about fires? What about being thrown free? Well, the National Highway Traffic Safety Administration, along with other organizations, have looked at this issue and again and again and again come up with the same results, that seat belts save lives, seat belts reduce injuries, seat belts make a huge difference in crashes. You can see the statistics. Those come out of a number of different NHTSA publications. And even when we drill down onto the state level and look at state data, and I'm going to use Montana in a number of instances as a case study because they have some pretty good data and do a pretty good job of making it available, even they note that a very high proportion of fatalities in the state, even recently, are attributed to not wearing a seatbelt. And if you think about those statistics we were just looking at, 9% aren't belted, but 68% of the fatalities are among that small population. That gives you a pretty good idea of just how beneficial seatbelts are. So that's a second basic fact. A third basic fact, Glenn, if we can move to the next slide, please. Thank you. Is, again, no surprise that people who are not belted but involved in crashes run up bigger bills that are passed on to society. They're passed on to taxpayers. They're passed on to other people in their insurance pools. They get picked up if Medicaid is picking up or Medicare is picking up the tab, then those increased costs from somebody not wearing their seatbelts get addressed all throughout the society. And that's something that everybody becomes a victim on because of those unnecessary costs driven by the lack of belt use. So we got three basic facts that I don't think really are arguable at this point in time. Belts are accepted, belts are widely seen as effective, and belt non-use costs people money, costs everybody in society money. Well, let's turn then to these gag rule statutes. That's the ultimate irony here, that even though all of these facts are undisputed, most states today, either bar outright or in effect bar the jury from making any meaningful use of seatbelt non-use evidence in court, even though they're accepted and even though they're effective. And this incongruity is why we're here to talk about it. Why do these statutes make any sense? And why would we persist in keeping these statutes on the book if their belts are effective, if belts are accepted, and if belts cost more money? That's what we're here to talk about. And that's what we're here to try to raise the visibility of, because it doesn't make a lot of sense. And we're starting to see efforts, most notably in Louisiana just this last year, to try to roll back these statutes that really don't make a whole heck of a lot of sense. Now let's take a look at an example of one of these. And again, I'm going to use Montana because it's a simple and pretty straightforward example of one of these gag rule statutes. The language of their statute is laid out on the slide, and you can see it's very bold and very straightforward. Seatbelt use, compliance with their mandatory use law, is not admissible in any civil action, and a failure to use a belt cannot be considered negligence. Period. End of statement. That's it, and it's a clear-cut bar. I'm going to point out to that box at the bottom of the slide that it was enacted in 1987. That's important for reasons that we're going to talk about here in a couple of minutes, and that's consistent. Really pretty much all of these statutes were enacted during a period in the 1980s and maybe very early 1990s, when there was a particular set of circumstances that drove this result. But now let's take a look at how these statutes get used. And again, I'm going to use a case study from Montana, and this is an actual lawsuit that I worked on with one of Doug's colleagues, involving a horribly tragic accident with a couple of young people doing the sorts of things that there but for the grace of God go I. They were out drinking on a weekend on a country road, coming back from this party in the woods. They made a mistake. The driver let himself get distracted, and on a narrow mountain windy road reached down to mess with the radio, and left the road and rolled down a hillside. The unfortunate thing is they were both unbelted, and the young woman who was his guest was pitched out through one of the windows, ejected from the vehicle during the rollover sequence, and was killed in the event. Horribly tragic situation. Would have been a very, very different situation had she been wearing her seatbelt. She decided to sue Ford Motor Company as a result of this accident for a crashworthiness claim, claiming that something should have been designed differently about the windows where she was ejected through, ignoring the fact that she wasn't wearing her seatbelt, and that would have likely prevented her accident and certainly her injury. So this case is litigated within the context of that gag rule that we were just looking at, and let's see how the court played out. That went to a decision, and the court looked at that gag rule, and even in the context of that clear-cut accident, an occupant who was unquestionably not wearing her seatbelt, who is claiming crashworthiness on the part of the vehicle was the cause of her injury, i.e. the failure of the vehicle to protect her. She was not using the primary occupant protection system provided with that vehicle, but yet evidence of seatbelt use had to be precluded. Expert testimony about that had to be stricken. Not a word could be breathed at trial about her failure to use the seatbelt in that accident, even though she's claiming the car didn't protect her. How does that make sense? And the answer is it really just doesn't. But that's an example of how these gag rule statutes play out in actual practice. So with that background, why does it make sense to drop these gag rules? For a number of reasons. First off, at this point in 2021, juries expect motorists to wear their seatbelts. They've been conditioned by decades worth of advertisements featuring our friends Vince and Larry. They're the crash test dummies with click it or ticket, or other slogans that are designed to make people think about wearing seatbelts every time they get in a vehicle, every time they think about driving. And yet we somehow expect these jurors to put that idea completely out of their mind when they walk into a courtroom to decide the outcome of a car crash case. How does that make any sense? These jurors know that seatbelts are widely used. They understand that the law mandates belt use in 49 out of 50 states, and they understand that police enforce these laws. And yet we're asking them through these statutes to overlook that fact. Why else do these statutes not make sense? Because the gag rule rewards risky conduct. We mandate seatbelts for a reason, because it increases injury, because it increases cost.
Lee,
and
if I could just jump in, I just want to comment on the topic here on your slide. We've tried cases where seatbelt non-use was inadmissible, lost the case, and then after the trial's over, all the lawyers go and talk to the jurors in the hallways. And when the jury finds out that after they dedicated 3-4 weeks of their life to a product liability case, and everybody in the courtroom knew that the injury was caused by the plaintiff's or the decedent's lack of seatbelt use, except them, they're furious. They become mistrustful of the civil justice system. They feel used. And that is a key way to communicate to legislators, to convince them. So Lee, you had that up on the slide, so I just wanted to jump in on that.
Absolutely, and thank you for doing that, Doug. It is doing the jurors a disservice, and it's frankly lying to them about key circumstances of the accident. So if we can move to the next slide, what kind of businesses are affected by these gag rule statutes? Well, pretty much any kind of business that has exposure to transportation over the road, which, if you think about it, is almost every business. Their customers are on the road, their products are on the road, whether it's a trucking company, whether it's an insurance company, delivery outfits, any sort of product that is moving involves some sort of exposure to potential crashes, and that involves seatbelt use. So this is something that has very widespread application. Yeah, but so now let's talk a little bit about why I keep saying that these are outdated. So let's talk about how they came into effect. And you're looking at this slide and you're probably wondering, why on earth am I looking at a picture of Cyndi Lauper? How does that make any sense? And if we're talking about seatbelts, here's why. When I think about Cyndi Lauper, I see an emblem of the 1980s. She's an icon of that era and forever connected with pictures like this to a certain time and set of circumstances. Exactly the same thing applies to these seatbelt laws, these gag rules that are on the books in most states. They came about in the 1980s as a result of a particular set of circumstances. What started this all is, in the 1980s, seatbelt use rate was at about 14%, and it wasn't moving. Despite advertising, despite efforts on the part of the auto industry, nothing was changing. The U.S. was lagging the world in that regard. We looked around, we saw what was going on in other countries. Mandatory use laws were being enacted, but in the U.S., that's going to be a state issue. We see courts that are looking at the issue and thinking, okay, most states at that point in time had contributory negligence as opposed to comparative fault. And with very few people accepting belts, there was not a lot of reason to let the evidence get considered and to drive the issue. The other critical thing that was happening is that airbags were emerging as a new technology, and a lot of folks were relying on that to get us out of the picture. That seatbelts really weren't going to be essential because we could just wait until airbags come in, and that's going to solve the problem of crash-related injuries. That's how things started. So the next step, in 1984, the federal government, and Elizabeth Dole here on the slide was the Secretary of Transportation at that point in time. And in 1984, the Department of Transportation comes up with a great idea. They propose this. they issue a rule through the Federal Register that mandates that airbags are going to be required equipment that auto manufacturers have to implement, raising prices and adding to vehicle complexity. That's going to happen unless the states intervene. And how can the states intervene? If states representing 2/3 of the population enact mandatory use laws by a certain point in time in 1989, and those mandatory use laws have to contain certain content. One piece of that content is that they must allow non-usage of seatbelts to be admissible in civil litigation in order to mitigate damages. That's a requirement. So that rolls out in 1984, and the states are now picking up the issue. What do they do with it? Well, the policy determination that many states go through is they decide they want to have mandatory use laws and encourage their people to use the seatbelts, but they also want mandatory airbags. Why can't we have both? And in fact, that's what the gag rules are really all about. So for the next few years, between 84 when this starts and 88 when we're looking at the last legislative session that would count, every state in the country considers mandatory use laws. 31 enact them, as we saw in Montana in 1987, but most of these states use that mitigation requirement as an opportunity to avoid counting their state against the Department of Transportation's total. Some of them did it because they were looking at this as really a civil liberties issue and taking a libertarian tack. A lot of them were looking at it as we wanted both airbags and belts to be effective safety technology incorporated into vehicles to protect our state's occupants. So they shot back. And to this federal overreach as they saw it. And so they enacted these bills that required usage of seatbelts by occupants, but barred consideration in civil cases of non-usage. Okay, so how's this all play out? Well, as we saw, 1989 is the key date, and that comes and goes. The 2/3 of states that are needed in order to forestall the airbag mandate, they weren't there. They didn't materialize. So the airbag mandate goes into effect. Airbags have been mandated in automobiles since the 1998 model year, and so that whole circumstance has now come and gone. The outcome has been driven, and it's now more than 20 years in the rear view mirror. So you would think that with the justification for them gone, it might be time to revisit the statutes, but it hasn't happened. So we are now stuck with these dinosaur statutes that were put in place to address this particular point in time, this particular political context that's now long ago, and yet we're stuck with these laws. With that, I'm going to turn it over to Tom, and he can pick up the discussion from there.
Thank you, Lee. That was great. I think, my first thought about this whole issue is I can't believe we're sitting here in the year 2021 still talking about these statutes, which really, when you dig down and talk to people, the only people that still support these statutes are plaintiffs' attorneys. And as we go through here, we'll see why. And let me just, say to start, the reason that Doug's here and I'm here from car companies is because we've tried a lot of cases, just like Doug mentioned a few minutes ago, where the jury is just pissed off when they hear the reality and that this whole thing was hidden from them. So cases where the main safety system of the car is the seatbelt system, and the jury isn't allowed to hear that in a rollover accident or in any other accident, these systems weren't even being used. So let's go back in time and talk about the justifications for these statutes way back when Cyndi Lauper was on the charts. So when I went to law school in the mid 80s, comparative fault was just kind of a new thing coming in, and most states had the contributory negligence doctrine, which in most states held that if a plaintiff was at fault at all, they couldn't get any money. So what was happening back then, a lot of times, remember drunk driving, it still plagues us today, but back in the 70s and 80s, drunk driving was a way, way bigger problem before MAD and the Mothers Against Drunk Driving. So I think what got a lot of people's attention was a drunk driver would run a stoplight and broadside an innocent person who was injured. That person would sue the drunk driver, and the drunk driver was able to get out of it by claiming non-use of the seatbelt. And people didn't think that was fair. Well, contributory negligence has largely changed, as we'll see in a minute, to comparative fault. So that justification for these statutes is no longer really relevant. Second reason given back then for these statutes was, well, you really can't tell. It's really controversial whether or not somebody was belted. How can you tell? And as we'll see, that justification has really gone out the window, no pun intended. And third, back then it was, well, juries aren't sophisticated enough to separate damages. What was caused because of the impact and what was caused because of the non-belt use, that's too complicated. And as we'll see, that justification no longer really applies. So let's talk about contributory negligence. This is a great slide, very useful, showing how that whole landscape has largely changed. In most cases, most states, if a plaintiff is negligent, that the jury's allowed to apportion that negligence and apply comparative fault. There are still states that have either a 50 or 51% bar, but even that's continuing to change. And I think, comparative fault, pure comparative fault is clearly the trend. So that really doesn't justify these statutes anymore. Next slide. So can you tell if somebody was belted? And back in the 70s and 80s and even early 90s, that was a little bit of a controversy. And that's just not the case now. First of all cars now have airbags. All cars have electronic data recorders. And virtually all cars sold today, you can do a download and tell whether the seatbelt was buckled or not. It's just black and white. Plus, experts are a lot more sophisticated now. And even if we didn't have the EDR, in most crashes, you can look at the webbing of the belt and there are load marks, very clear load marks left. You can look at marks on the D-ring, and just about anybody can tell, both from the EDR and from witness marks in the car, whether the belt system was being used or not. So that's really not a justification anymore for these gag rules either. Apportioning fault, juries clearly have shown over the years in thousands and thousands of trials that they're capable of apportioning injuries. The reality is that back in the 70s, the second collision crash worthiness theory was just developing, and now jurors are really expected to be able to look at a car crash, look at the crash, and look at the injuries and how they were sustained, and apportion, fault based on all the factors that the experts are telling them in these juries. So again, that third factor really isn't a justification anymore for these outdated laws. The current reasons asserted for keeping the gag rule, little trivia question. I think I'm right on this, Lee. Correct me if I'm wrong, but you said 49 states have use laws. What's the 50th state that doesn't have them? I think it's New Hampshire, isn't it?
Gives a whole new meaning to the words live free or die that are on their license plate, right?
Yeah. So if you're in New Hampshire, maybe I guess, the live free or die, these justifications might make sense. But really, freedom of choice, I don't want to wear a belt because I might get injured. Belts cause injuries. All those things really have been proven wrong scientifically. So, these people still, it's a free country. If they don't want to wear a belt, they don't have to, but that's not a reason for these rules anymore. Again, who's not wearing belts? I don't really know. It's just since the early 90s, late 80s, when Doug and I started doing this work, usage rates were a lot lower, and people did have different attitudes, but people now, I mean, almost all, you do feel kind of naked without the belt. So things have really changed, and attitudes toward belts have really changed, and the data now has really changed. So there's really no argument on any of these issues. So really, the big issue is, are you going to be truthful with the jury and let them really know all the facts about what really happened at the time of the accident? Belts, again, we could go on for about 10 hours on data showing that seatbelts save lives, seatbelts reduce injuries, seatbelts are effective, seatbelts are the primary safety system in every car. Airbags are called supplemental restraints for a reason, because seatbelts are way more effective than airbags. Airbags are great, but look at this data. You can see that average damages, medical charges for belted versus non-belted occupants are 3 times, maybe more than 3 times higher for unbelted occupants. We could go, as I said, data on and on and on. In a rollover, unbelted occupants are, I think, 29 times more likely to get ejected than belted occupants. On and on and on, the stats support belt use equals safety. And who's paying for that? Society is. On average, you can see these stats in Montana. Those injured pay for about a quarter of their healthcare costs. The rest is, absorbed by society. So, and back to that slide that Lee showed, who's really absorbing it are companies that use the roads, trucking companies, delivery companies, auto companies. They're absorbing all these costs, and it's really not fair. Blaming the victim? Not really. I mean, it's really a question of personal responsibility. I think that's what this organization stands for, and what all these tort reform organizations stand for is juries hearing the whole story and personal responsibility. It's not blaming the victim. It's, we all have the responsibility to buckle up, and if we don't, we've got to take some responsibility for that. Juries should hear the whole story. That's what tort reform mostly is all about, in my view, is just giving a fair playing field by allowing the juries to hear the whole story. And most of the time, in my experience, when they do hear the whole story, juries do the right thing. So Texas Supreme Court's addressed this. Even when trial courts properly admit seatbelt evidence, defendants will be held liable for damages they caused because of this apportionment that juries are allowed to do, but not the injuries the plaintiffs caused by not using a seatbelt. That, it seems to us, is fair. And again, this is just an outmoded belief from people 30 or 40 years ago. It's been proven by data wrong. It's true. Maybe in 1 in 100 cases, seatbelts can, under certain circumstances, cause injuries, but it is very rare. Data goes on and on. CDC, NHTSA, all the federal statistics, all the private studies. I mean, the evidence is overwhelming about the safety of seatbelt use. And you're going to see in a few minutes some good examples from Doug, which belie that belief. I'm going to turn it over to Doug right now. Doug, I think you're muted.
Thanks, Tom. Gets me charged up just hearing those stories. So a couple of years ago, I sat down to testify in front of a state transportation committee in support of a bill that would make non-use admissible. And the chair of the committee took the mic and said something along the lines of, well, as we all know, sometimes seatbelts help and sometimes seatbelts hurt. So it's really just a crapshoot. Okay, Mr. Lampe, what would you like to tell the committee? So, but here I'm speaking to people affiliated with the Washington Legal Foundation, the smart people. I get that this audience understands this, but what we're trying to do here is prepare you for comments you might get in a state house or in discussions with a member of your state or local bar. And sometimes I think there is intentional confusion about what a bill is that makes admissible non-use. In a state with a libertarian bent in particular, lawmakers may have confusion, pretend or otherwise, that our bill has something to do with mandating belt use. But their state already has that bill. So making admissible as evidence non-use needs to be understood and clarified that it has nothing to do with the mandatory use law that already exists. And so in the testimony I just reflected upon, after that comment, other members of that state's legislature then reflected that confusion. And they actually got other members then rallied up. So, you really need to be prepared to detangle mandatory use law with evidence admission. So let's talk about how we can convince people like this chair of transportation that belt usage is not sometimes they help, sometimes they hurt. Let's look at the next slide, which you're going to enjoy. It's a video of a crash test. So this is what's known in the industry as a dolly rollover. The vehicle is placed on a dolly. The dolly's on a track. The dolly's moving down the track at a set speed. And the dolly then hits a stopper. So the dolly stops instantly. The vehicle, not attached to the dolly, then continues. And hopefully the video shows, so I don't have to do a verbal rendition of this. And if we
Sorry, I can't seem to get the video to play, so I'll keep trying. I apologize for that.
That's fine, Glenn. And if you would like to try the next slide, I can make the point without that one. We're going to come back to another video later, even if that one doesn't play. So don't worry, you are going to see a crash test video. So this is just some messaging that Ford has used, and I know Hyundai and Tom have used in their efforts as well, that really focus on the juror, because it can be hard when you're a large corporation to come into the state house and say, protect us at the consequence of your in-state resident. But what this does is it properly focuses this question on the jury and really reflects on the fact that we have adopted a system that juries decide facts. And whether or not the belt usage or non-usage affected the outcome here is just a fact that is core to what juries do. So we have had great success in convincing on-the-fence legislators by using the prism of the jury to convince them. There's a way to do this, and it's really not that hard. 11 states have gotten this fixed. A couple did it on their own. Lee's been involved with some. Tom's been involved with some. I've been involved with some. ATRA's been, the American Tort Reform Association's been involved. And we just want to make non-use admissible in any civil proceeding, not just product liability, and without limitation. Next. One little cautionary tale, you would think that this is a bad law adopted in 1986, for example, just repeal it. The problem is when those statutes were put in place, in a lot of the states, there were already bad common law from the 70s when belt usage was more controversial and when contributory negligence was the rule of the land. And we've got some state Supreme Courts who had decided in the 70s that belt usage or non-usage is inadmissible. So you can't just repeal unless you have mastery level knowledge of the common law. You really need your own statute. And the model bill content, one, it should be all civil cases, not just product liability. Two, it should be applicable to all occupants. One of the carve-outs that a legislature usually tries to make, once it looks like the bill may pass, you're going to get some amendments to carve out minor children in the back seat. We can't hold the minor child responsible, or they will carve out the back seat regardless of occupant age by noting that that state's mandatory use law is only applicable to the front seat occupants. And if there's no mandatory use law in the back seat, why would the evidence be admissible? And of course, I think everyone on this call would know exactly how to deal with that. Evidence admissibility is about the jury's adjudication of facts, and it's disconnected from mandatory use law. You should be able to use it for determining comparative fault or for mitigation of damages. Some states allow it to be used, like Missouri, but limit the amount a jury can apportion to 1%, which is, nearly useless. Next slide. Okay, so if we have any luck playing the videos, we'll do that now. Otherwise, we're open to questions. Let's give Glenn a minute to see if the video rolls. Okay, here we go. We've got a Volvo XC90 moving down a track. The dolly's going to stop. The car's rolling. The airbags and the canopies are disabled to prevent the camera views from being disturbed. Oh, there's a dummy that comes out. I thought you wanted to be thrown clear. No. Oh, the dummy's going to get run over by the car. There's another dummy coming out. You can see what's going to happen to the femur and the forehead. So these type of videos are really compelling to a legislator who thinks being thrown free is optimal. Here you've got a Ford Explorer on a dolly roll. Again, the side airbags have disabled so the camera view is not disturbed. That was a dummy that went up in the air. Wait for it to come down. Comes down off camera. Now we're going to show you video. Okay, this is
it's the high-speed version of that.
This dummy goes up so high, they go off screen. Another dummy just got run over. There's another one flying away. Oop, there's another. So we got 6 dummies in the vehicle. At least 5 are ejected. All of these, of course, would be fatal injuries upon landing. Okay, now we're going to contrast this with what it looks like on the inside of a car when you've got belted occupants. This will be fairly unremarkable from the exterior because there's no dummies coming out, which of course is the whole point. And then Glenn, after this one, we could play slide 31, which will show the interior view of this crash. So there you see the dummy's head is just got light gauge tape on it, so it stays in position for the first. Now that it's already broken, so it's the roll has started. You can tell by looking through the windows the horizon is changing, so you are seeing the vehicle is rolling. Dummy's in its seat. It's got a side airbag holding it in place. This is a very bad, rough event for this dummy. And I don't want to minimize it, but obviously on a whole different order of magnitude compared to the dummies you saw that were thrown free of the vehicle. Great. Well, that's the show and tell part. Lee and Tom were generous enough to give me the fun stuff. Now let me turn it over either to Lee or Glenn, and we can invite your questions. Thanks for your time.
Thanks for the presentation, guys. Those are fantastic. I was hoping to have Lee talk a little bit more about the Louisiana law. That was a really fascinating working paper that he wrote for us. And as I had said to everybody that's on, if you want to download a copy of it, just click on handouts. But I thought you did an excellent job in the working paper, sort of contrasting the way that the law was, looking at Texas as to how their law was, and if you could also talk about how it's kind of in the hands of the Louisiana judiciary now as to whether or not they carry the law out properly.
Thanks so much, Glenn, and I appreciate your kind comments about the paper. So Louisiana, which made its change just this last legislative session, fell into the bucket of what Doug was pointing out as potentially a problem of a straight repeal. So they had a gag rule much like most other states and simply repealed it. And so now the question becomes, okay, what is the law? There's no statute on the books. There are 30 years worth of common law decisions coming from the courts, many of them relying on that statute to say, well, the legislature has spoken, so our hands are tied, and they say the evidence can't be used. And then if we go back before the statute was in place, there are some really old common law decisions that say, well, because it's comparative, or because it would be contributory negligence, and because these aren't really accepted, we don't think this is a proper consideration for jurors. So at this point, now if the issue arises in a Louisiana court, what do you do? What is there? And the answer is it's kind of a blank slate. You had this statute, but now it's gone. And so you've wiped out all of this jurisprudence that relies on the statute, and you're depending. And I think there's a strong argument to be made that clearly the legislature was trying to do something. And by repealing this law, they were certainly trying to wipe off the books this wayback machine that these laws represent. And in order to draw an analogy, they really just need to look to what happened in the state next door to them, and that's Texas, as Glenn mentioned, which went through exactly the same process starting in 2003. They had a straight repeal of their gag rule statute, but unfortunately, they had courts that were hung up on those old common law decisions that dated back to the 70s and early 80s, and couldn't convince themselves that it's time to move forward. And it ultimately took the Texas Supreme Court in a really fascinating and I think very well done opinion in 2015 called Neighbor Wells that addressed the issue and looked at it in light of all of the things that we've been talking about today: the change from contributory to comparative fault, the acceptance of seatbelt use as a statute, as a societal norm, the recognition of the efficacy of belts, and putting all of that together, reached a conclusion that no, we no longer need to or want to rely on these cases from the 1970s and 1980s to guide us. And so hopefully Louisiana will be able to fast forward and not have to go through a decade or more of those growing pains to get to the same result that Texas ultimately did. And that's what that working paper is really all about. And that, and summarizing some of the discussion that we've gone through today about why these gag rules came into effect, and the fact that they reflect a certain political situation that was present in the late 80s and early 90s that no longer justifies the existence of these gag rules. And honesty to the jury really compels the need for this evidence to be considered.
Well, with the gag rule repealed, I think you go back to first-year evidence law, and if evidence is relevant, and it's helpful to the jury, and it's more probative than prejudicial, the jury should hear it.
And certainly it makes an impact on the outcome, right? I mean, as we looked at about 9 different slides, if that person is belted as opposed to unbelted, the chances of them racking up big expenses or fatalities are much, much reduced.
That's right.
One of the things that we've seen in evidentiary law at the state level, for instance, in Florida, where the legislature tried to change the standard for expert evidence testimony to the Daubert standard away from the Fry standard, and then the court came in and said, "Hey, this is a court rule. We're the ones that need to change this." Has that happened at all in this area, or do you foresee that happening in any state?
Yeah, I can address that. It's interesting. In one state that I know of, that has come into play. That state being Arkansas, where they followed the same path that most other states did. They enacted a gag rule in the 80s, and it was on the books for a couple of decades. And then an enterprising defense lawyer for a trucking company actually made the challenge that violates separation of powers under the Arkansas Constitution, and took it up. And the Arkansas Supreme Court agreed with that notion and wiped that statute off the books as a legislative encroachment onto judicial turf. And this lawyer who undertook that in Arkansas was very savvy. Arkansas was one of the very few states that had old common law predating their gag rule that said, sure, this is a proper consideration for jurors. But I think Arkansas is very unique in that regard. In virtually every other state that I have looked at, there's been deference on the part of the court to the legislature, and in fact, Louisiana, as we've just been talking about, their Supreme Court has said, look, the legislature has entered into this fray. They have decided to speak. This is clearly a manifestation of a policy decision and not an attempt to dictate to the courts how things are supposed to work out there. And so, we're going to defer to their judgment on this issue, and that's been the case in most places. But Doug, Tom, what do you think?
Yeah, I think that's right, and I would add 2 things. One, in the 49 states other than Arkansas, there's now multi-decade experience with accepting the legislature's pronouncement that it's not admissible. So a change that says it is should not draw higher scrutiny. But the other thing that I've always worried about after the Arkansas, because we thought of, well, should we take the Arkansas model and apply it? But we have other civil justice reform initiatives unrelated to seatbelt, and the Arkansas argument could detract from some of those. So it's a tough one to deal with.
Tom, any thoughts on that?
No, but the one thing we could at least Doug and Lee and I could talk about for hours, we just have a minute or two, is some of the nonsensical trial situations that we've found ourselves in over the years when, for example, in a frontal collision, a woman has the seatbelt under her arm and it rides under her rib cage and maybe lacerates her liver, and that's what causes the injury. And plaintiff's attorneys are attempting to try this case without talking about the belt. And so we have experts that are walking a tightrope, in a rollover. Gee whiz, the driver's head hit 6 feet over that way, hint, nod, so that the jury understands that the plaintiff or decedent wasn't belted. And it's just a fallacy. And it gets, almost like a Monty Python show at some point. It's just ridiculous. And again, if you talk to 100 people at the mall and ask them about this, you'd be hard pressed to find anybody who wouldn't find these laws just ridiculous at this point. Yet somehow, I don't know, Doug and Lee, you would know more. How are the powers that be able to keep these things on the books? I mean, it just seems so ridiculous. But
really, what they do from a procedure standpoint is try to deny a hearing. Because no one really wants to vote against it unless you're clearly affiliated with the plaintiff's trial bar. And unless you just caucus with the trial lawyers, you don't want to vote against this. So one of the ways they do is what I believe is intended confusion, that this has got something to do with the mandatory use law. That's a classic one. Or I'll support, but here are my 11 exceptions. Nobody under age 18. Nobody in the back seat, nobody in this class of vehicles, which happens to include trucks that weigh more than 5,000 pounds. So they don't want to say no. They say yes in such a way. It'd be such a bad bill that you'd rather pull it down and try again the next year.
Yeah. Another exception that I see added is to really load up the burden of proof so it becomes so expensive that in all but the most extreme case, it's economically unviable. So there's a demand for expert testimony or expert medical testimony that establishes not only that somebody would have been better off by being belted, but exactly what the difference in injuries might be. And so now an expert is charged with trying to reconstruct an accident that didn't really happen. I mean, how can you tell exactly what an injury might have been in, for instance, those dolly rollovers where somebody is completely pitched out of the vehicle, but the vehicle was involved in an incredibly high-speed, high-energy event, and so sure, there were a number of impacts, and there might have been some modest injuries, even if somebody was belted. But that becomes almost an evidentiary impossibility, and certainly an economic drag if we've got to get medical testimony in every case to establish the difference.
And especially in the case that you were describing, Tom, one would think that there would be situations where the jury would slip the judge a note and ask, can we find out whether or not this person is wearing the seatbelt? And I don't know if either of you have ever seen that or if Lee has ever seen that, but that just seems like kind of an obvious situation where the judge would have to say, no, we can't give you that information.
Well, I can't remember a note situation, but like Doug said earlier, I can remember talking to jurors after verdicts, and they're not just a little bit angry, they're livid. Are you telling me I spent a month of my life doing this and I wasn't told that the decedent was unbelted? I mean, it's really offensive. It's wrong.
I think we can end on that note because that seems to sum up pretty much the entire argument one can make against these laws. Thank gentlemen for taking your time to do this with us today. And thank you everybody for attending. This is going to be available as an on-demand video later on this afternoon. And once it's up, you'll all get an email saying that it's available. Please share it widely. Our purpose for doing this was to get people to understand in the most basic way that you can that these sort of rules are antithetical to basic fairness and due process and just the common sense rule of law. I especially thank Lee for bringing this together and putting together the slide deck, which was fantastic. I'm sorry that I wasn't able to get the slides to work in the right order, but at least we were able to see the very dramatic videos that
work great.
really make the case dramatically. Wished all of you a good rest of the week, and thanks again, everybody, for joining in.
Thanks for hosting, Glenn.
Thank you, everybody.
Thank you so much. This has been great.